Assigned Lands Prohibition of Transfers Act 1977. Section 5 of this Act deals with the prohibition of registration of assigned lands. This means one cannot register the assigned land. Generally, the transfers are not prohibited nor the registration. But under the assigned land, the government allotted the lands to the landless poor persons for their welfare. The land assigned by the government to the landless poor person for the purpose of cultivation or a house site, it is not capable of being transferred, and it will deemed ever to have been transferred. Even the registration is not allowed. There is no registration of assigned lands. Nowadays, it is common to find in almost all the sale, gift, exchange deeds being registered a clause stating that the transfer is not prohibited under the Act of 1977. This is because under Section 5 of the Act, no registering officer is competent to accept for the registration any document relating to transfer of assigned land. In fact, the state government is required to furnish a list of assigned lands in the district to the registering officer for this purpose. An assigned land can be transferred by the registration only after obtaining the prior permission of district collector, probably subject to the provision of Section 4 of the Act. Section 5 of this Act has an overriding effect. It renders the Registration Act inapplicable to the assigned lands. Subsection 2 of Section 5 states that notwithstanding anything in the Registration Act 1908, no registering officer shall accept the registration of any document relating to the transfer of or a creation of an interest in any assignee as furnished in the end list of subsection 1. In other words, the assigned lands means the land assigned by the government to the landless poor persons subject to the condition of non-alienation. Such assignment denotes the grant of land at the disposal of government to the individuals either on payment of value or free of cost. Such assignment was made with the condition that assigned lands could not be alienated, which means these assigned lands cannot be transferred. If found alienated, the government would resume the same. If someone alienates the assigned land, the government would take over the land. However, the past experience has shown that the substantial extents of the lands which had been assigned to landless poor persons have actually been alienated and ended up with the hands of the well-to-do persons. Since such alienations defeat every object with which the assignment has been made, the government has thought of a protective legislation in the form of present act. So these assigned lands are allotted for the benefit and the welfare of landless poor person, so it cannot be alienated, and no registering officer shall accept for the registration of any document relating to the transfer of assigned lands.